Hello and welcome to ProfDale's Property Video number 36. I'm your host, Dale Whitman. In this video, we're going to cover two topics. First, how to determine the scope of an easement, and second, how easements can terminate. We'll start with the scope of easements, but we might ask, what do we mean by the scope of an easement? Well, a scope question is really the answer to this. If I have an easement, what am I allowed to do with it? That's what scope means. Now, the basic scope of each easement is determined by the way it was created. And because, as we know, there are 4 different ways of creating easements, there are 4 different ways of looking at the initial scope issue. The first kind of easement that we can talk about is the express easement. That's one that's created by words. And what we do, of course, to learn the scope is simply to read the words. The easement may say it's for a driveway or a power line or a sidewalk. And so we know the initial scope just by reading those words. If the easement is silent, if it doesn't state what its purpose or scope is, then the court will have to infer that from looking at the party's intent and the surrounding circumstances. The second kind of easement is an implied easement. That's one that's implied from prior use. Before the easement was an easement, it was a quasi-easement. That is, one part of the land being used to benefit another part when they were all in common ownership. So what we do is to look at the use when it was a quasi-easement, before the lots were split apart. And that will give us the core scope that the easement has when it becomes an actual easement. The third kind of easement is an easement by prescription. That's the one you remember that's similar to adverse possession. And here what we do is look to the use during the prescriptive period, the period when the use was illegal and adverse. And that indicates to us the scope that the easement will have once it arises at the end of the prescriptive period. The final kind of easement is an easement of necessity, and that one is strictly limited in its scope. It's only for access and utility lines. But the basic scope that we learned about on the previous slide isn't necessarily the final answer. The reason is that easements can evolve over time. One way is that reasonable increases in the intensity of the use are going to be permitted. For example, if the water company has an easement for a water line and their customers at the other end of the line need more water, the water company might want to install a bigger pipe. Well, that's probably going to be considered a reasonable increase in the intensity of the use, and therefore it'll be fine. Another example is that if there's an appurtenant easement, it goes to some dominant land, and the intensity of the use can be enlarged to accommodate reasonable development of that dominant land. For example, if the dominant land is subdivided, giving rise to more users who want to use a driveway easement going to that dominant land, then the court will probably say, if the subdivision was reasonably foreseeable and it's a reasonable development of the dominant land, the increase in the users on the driveway is perfectly okay. Another way that easements can evolve in their scope is because of technological change. Reasonable changes in the technology of the use are permitted as long as it's the same basic use. So an easement that was originally given for horse-drawn wagons can now be used for modern trucks or other vehicles. But there are some kinds of changes in the use that simply are not allowed. One of them is changing to a different basic type of use. For example, if we have an easement for a driveway, we can't use it to put in a water line. A driveway and a water line are simply totally different types of use, and the water line would be outside the scope of the driveway easement. Similarly, we can't use an appurtenant easement to benefit any land other than the original dominant land. In other words, we can't glom additional land onto the dominant land and expect the easement to benefit the additional land as well. Here's an example. Suppose there's an easement over A's property to benefit B's land, and B's land is the dominant land. B proposes to build a house which is partly on the original dominant land and partly on parcel C, which isn't part of the dominant land at all. Well, what the law tells us is the easement cannot be used to benefit any portion of Lot C or the house that is built on Lot C. It can only benefit the original dominant land. Now, questions about what's within an easement scope are often litigated. In fact, one of the most common types of litigation these days is whether a fiber optic communications cable can be installed on an existing easement. You can easily see that communications companies, if they had to go out and acquire brand new easements for fiber optic cables, would incur huge amounts of expense. So they'd much prefer to piggyback on an existing easement. Well, whether they can do that depends on the type of original easement there was. For example, if the original easement was for telephone lines, almost certainly a court will allow fiber optic cables to be strung on those same poles because, after all, both fiber optics and telephones are forms of communication and they look similar, and therefore no problem with adding the fiber optic cable. What about a power line easement? Well, that's really a different type of use. Communications and power are different functions. Nevertheless, the optic communication cable will look a great deal like a power line. It's basically a wire, and therefore the court may say, well, visually and in terms of function, it's close enough to a power line that will allow it to be added to a power line easement. On the other hand, what if the easement was originally given for a pipeline or for a railroad? Now here, there's a huge problem because fiber optic cables are not inherently in the nature of running a pipeline or a railroad. If the fiber optic cable was used only to benefit the pipeline company or the railroad company in its internal communications, it would probably be allowed. But if it's going to be used to benefit a wider communication audience, the answer is likely to be no. That's outside the scope of the easement. Similarly, could you put a fiber optic cable on a driveway easement? Well, as we suggested in the previous slide, it's simply a totally different type of use and probably will not be allowed. That completes what we need to cover about scope of easements. Now we're going to spend the rest of this video talking about the way that easements can terminate. By the way, the termination of easements is very similar to the termination of restrictive covenants, which we covered back in video 33. So if you're interested, you might want to compare the two and see what the similarities and a few differences are. The first and perhaps most obvious way that an easement can terminate is by its expiration based on the terms that were included in the original creation of the easement. Now, most easements are in fee simple absolute and they last indefinitely into the future. But an easement doesn't have to be in fee simple absolute. What if the easement said, I grant this easement to A for life? In effect, instead of a life estate, we have a life easement there. The easement might say, we grant this easement to A so long as it continues to be used as a water line. The so long as language should remind us of the fee simple determinable, and this is indeed an easement in fee simple determinable. What about I grant this easement to A for 10 years? That seems like a leasehold estate, but instead of an estate, of course, it's a leasehold easement. A second way that an easement can terminate is by being released by the person who holds the easement. Let's take the example of an easement for a driveway that A has over B's lot. A has the dominant land and B has the servient land. Well, suppose A executes a deed of the easement itself to B. Now you might be thinking, wait a minute, can you do that? Can an appurtenant easement be conveyed separately from the dominant land? And normally the answer to that, of course, is no. The easement can only be transferred with the dominant land. However, this is an exception to that rule. It's okay to transfer the easement back to the person who has the servient land. Well, now what happens to the easement? The easement and the servient land merge together. In effect, the easement just sort of sinks into the servient land and disappears. And that's the end of the easement. Here's a variation on the release situation. Let's suppose that A gives a conveyance of the easement to B, but the conveyance is only oral. A just says to B, I don't want the driveway easement anymore, you can have it back. Does the statute of frauds apply? Well, it certainly does. We're conveying an interest in land, and normally the statute of frauds says that any conveyance of an interest in land with a duration longer than 1 year has to be in writing. Since there's no writing here, this won't be an effective release. However, let's suppose that B believes that it is an effective release. And so B, in reliance on the fact that the easement has now been released, spends $5,000 re-landscaping the southwest corner of B's lot where the driveway easement used to be. Now, the expenditure that B has made in reliance on the oral statement will act as an estoppel against A, will prevent A from using the easement in the future, and in effect, A's easement is terminated by the function of the estoppel. Now, there's a big difference between estoppel arising from words that someone says and an estoppel arising from silence. To illustrate that, let's again assume that A has a driveway easement over B's land, and B begins building a garage on B's lot that will partially block off A's driveway easement. And let's suppose that A sees this construction beginning, can see where the garage is going to be located, but says nothing about it to B, doesn't make any objection or complain about it. Let's suppose now that B completes the garage. Is A going to be estopped to use the easement in the future because A didn't complain about it? The answer is almost certainly no. The courts are extremely reluctant to find an estoppel simply from silence, simply from the fact that someone said nothing when someone else was apparently about to take an action that would harm them. Now we can change the facts. Let's suppose that instead of being silent, A says to B, I see that you're building a garage that's going to block my driveway, and I don't mind you doing that. Now we have affirmative words. If B goes ahead and completes the garage, almost certainly the courts will find an estoppel and will find that the driveway easement has been terminated. A third way that an easement might be terminated is sometimes called adverse possession and sometimes called prescription. I like to call it prescriptive blockage myself. Here's what happens. A has a driveway easement over B's land, and B builds a wall or a fence on the boundary that blocks off A's easement. Now, obviously, that's illegal. A could bring a suit, get the fence or the wall enjoined by the court, but A doesn't do anything about it, and time goes on, and finally, let's suppose after 10 years, which let's stipulate is the adverse possession period in this particular state, B now says, by virtue of my adverse possession or prescriptive blockage of your driveway easement, it has been terminated. And the courts will agree with that. So in other words, just as an easement can be created by prescription, an easement can be terminated by prescriptive blockage as well. An easement, in number 4 here, can be terminated by merger. Merger arises from the idea that you can't have an easement on your own land. If you own an easement, it has to be on somebody else's land. So let's suppose that A has a driveway easement over B's land, and let's suppose that either A buys B's lot or B buys A's lot. Either way, the two lots are now in common ownership. What happens to the easement? Well, obviously, the easement is terminated because now the same person owns both the dominant and the servient land. And, as I said, you can't have an easement on your own land. A fifth way that an easement can be terminated is by abandonment. And here we ought to point out that there's a big difference between easements and estates. You know, you can't lose an estate by abandoning it. Even if you don't go near it for many years and you tell everybody around that you don't want it anymore, it's still your property. So estates can't be lost by abandonment, but easements can be lost by abandonment. There are two facts that have to be proven in order to show that an owner of an easement has abandoned it. The first one is a long period of non-use of the easement. You might ask, how long? Well, the courts are not very specific about that. Probably something approaching the adverse possession period is going to be necessary. But in addition to not using the easement for a long time, there has to be some additional evidence that the holder of the easement no longer intends to use it. Evidence over and above just not using it for a long period of time. So what sorts of additional evidence will work? How can we prove an intent to abandon the easement? Here's one possibility. The dominant owner who holds the easement tells neighbors, oh, I never plan to use that driveway again. That certainly shows an intent to give up the easement? How about the owner putting in a new and more directly routed driveway so that there's evidence that they don't intend to use the old driveway anymore because the new driveway is more convenient? Yes, that will work too. Or suppose the dominant owner builds a wall or a fence that blocks off his or her own driveway easement. Well, if you blocked off your easement, that's pretty good evidence that you don't plan to use it anymore. So any of those pieces of evidence will probably work to show that necessary intent to abandon the easement, and the easement then will be terminated. Here's a sixth way of terminating an easement, but it applies only to an easement of necessity. You remember an easement of necessity is created in order to provide access to someone whose land would otherwise be landlocked, like owner 7 in the picture that we have here. Let's suppose that owner 7 goes to court and gets an easement of necessity. Let's suppose it runs along the boundary of lot 5 there. So the court creates an easement of necessity, and then later a new public road is created and it touches the landlocked parcel, parcel 7. Well, now the owner of parcel 7 has no longer any need to use the easement of necessity, and the easement of necessity will be terminated. It exists only as long as there is absolute necessity for it. Now finally, here is a list of a few more ways that easements can be terminated. The first one is a tax sale of the servient land. If the servient landowner doesn't pay the taxes and the land is sold for delinquent taxes, in some states that will wipe out the easements on the servient land. That would be the common law result, but in other states there are statutes that expressly preserve the easements over the servient land if it is sold at a tax sale. So you just have to check your local statutes and see whether a tax sale will do it or not. A second possibility is a senior mortgage foreclosure on the servient land. Let's suppose that a mortgage is placed on the servient land before the easement is created. That means the mortgage will have priority over the easement, and if the mortgage is foreclosed, the easement will be wiped out. Another possibility is that the government condemns the servient land, takes it in what we call eminent domain for some public purpose. Now, when that happens, the easements are going to be wiped out, at least if the government needs the portion of the land that the easements run across. On the other hand, the easement holder will be entitled to compensation if the government wipes out their easements. Finally, some easements are in buildings rather than on raw land. You might never have thought of it, but if you rent an apartment or an office in an office building, you obviously have an easement over the hallways, the corridors, the external doors, the elevators to get from the outside world to your rental property. Well, those are easements in a servient building. And if the building itself is destroyed and isn't rebuilt, or at least isn't rebuilt to the same plans and specifications, then the easements in the servient building will be destroyed by virtue of the building itself being destroyed. That completes our coverage of easements. In our next video, we're going to turn to a new topic and talk about contracts for the sale of land and how the statute of frauds affects them. If you have questions or comments, email ProfDale01@gmail.com. Thanks for watching.